Okay, welcome back, students. And once again, this is the last session of today's lecture. Not only to the lecture, but this is the final session of our course, that is the international criminal law. So before the short break, we were discussing the how responsibility will be exclude when the conduct which is actually prohibited. But the excuse and defense will be acceptable regarding the related with the that conduct. So, what we have learned, the what forms of the individual's criminal responsibility. The various forms of the responsibility recognized by the leading international jurisdictions are set out as in national jurisdiction, domestic laws, or international criminal law does not merely hold responsible the person who pulls the trigger. It means a person is not responsible who actually pull the trigger of the gun or directly perpetrates the crime. It is also possible to impose liability upon the individuals who use or cause others to commit the crimes. Who commit crimes as part of a group or who deliberately help others to do so. Indeed, given that international criminal law is frequently concerned with the most serious crimes and those that occurs on an enormous scale, large scale, these other forms of the responsibility may in fact be the most significant. A senior politicians, for example, will rarely physically commit the crimes, but may be responsible for the thousands of the others so doing. Clearly, they should not escape liability merely because they did not get their hands dirty. In simple word, which means those persons they are very much senior and seasonal, and they do not put their hand in that crime, but what they will do responsible for the thousands of others will doing, which clearly liability merely because they did not get their hands dirty, but their minds are dirty. They involve their minds, their evil mission, their evil accomplishment must be involved in order to commit any crime. A general degree of the familiarity with all the forms of the responsibility applicable in relevant jurisdiction is crucial for all lawyers working in that area. It has been general practice at the ad hoc tribunals for the prosecution to plead a wide range of the modes of the liability in the indictment. Thus far, prosecutions at the ICC have been more narrowly focused, but this may be more a result of the circumstances than a deliberate policy decision. The forms of liability which exist at the ad hoc tribunals are similar but not identical to those set out in ICC statute. It would, however, be a mistake to think that ICC represents an entirely new legal paradigm. Although ideas from the ad hoc tribunal cannot be applied mechanically to the ICC, they may still influence the way in which the ICC statute is interpreted. The distinct sources of law should also be noted. The ICC statute as an international treaty is an authoritative source of law with respect to the conduct of committed after it has come into force. In large part, it attempts to codify all relevant matters, substantive and procedural, and binds only those states which have expressed their consent through ratifications. The status of the ad hoc tribunal, however, is very different. The method by which they were created varies, but they were all established after the conduct which they sought to try had taken place. These were the forms of responsibility. So it was the dues which we have discussed, necessities and other form of the coercions or circumstances which involve a person but person was not intended. Now, in this part of lecture, students, we are discussing the immunity, which is very different from the defenses which we have discussed earlier. The international law of immunities has ancient roots, extending back not hundreds but thousands of the years. In order to maintain channels of the communication and thereby prevent and resolve conflicts, societies needed to have confidence that their envoys could have safe passage, particularly in times when emotions and distress were at their highest. Domestic and international law developed to provide for inviolability of a foreign state's representatives and immunities from exercise of jurisdiction over those representatives. While immunities are valuable in preventing interference with the representatives and thereby maintaining the conduct of the international relation, they can also frustrate prosecution for very serious crimes. In recent decades, with the advent of the human rights movements, states have taken stronger steps to prosecute international criminals. This emboldened state practice has brought to the for many hidden or unresolved questions as to the boundaries between principle of the accountability and immunity, while international priorities are shifting in favor of the justice and accountability. It would be an oversimplification to assume that international criminal law has simply superseded immunities laws. Commentators have at times assumed that no immunity of any kind may be raised in response to allegations of the genocide, crime against humanity, and war crimes. But however, such view overlooks different kinds of immunities and is contradicted by the great bulk of the state practice and jurisprudence. Even the landmark precedents narrowing immunities explicitly affirms that there are still some immunities which apply even with regard to the allegation of the serious international crimes. A recurring argument against the immunity is that prohibition of the international crimes are jus cogens, and therefore any immunities must give way to the higher value of the ensuring prosecution. Such arguments have been considered and rejected in extensive line of the national cases in various countries, as well as the European Court of Human Rights and the International Court of Justice, as was recently observed by the House of Lords in the Jones case. The argument depends on the false conflict whose cogents prohibit committing the crimes. It does not mean that all international laws regarding prosecution cases cease to apply. As was explained by three judges of the ICJ, the principle that serious crimes must be punished. There's no any exceptions, there's no any excuse, does not ipso facto mean that immunities are unavailable whenever impunity would be the outcome. Immunities serve other purposes which have their own intrinsic value, and international law seeks the accommodation of this value with the fight against impunity, and not the tariff of one norm over other. A state makes exercise the criminal jurisdiction which it has under international law, but in doing so it is subject to other legal obligations. Therefore, a more sophisticated approach is needed. In order to understand this area of law, it will be necessary to appreciate the underlying principles and protective values to distinguish between functional immunity and personal immunity, and to distinguish between national and international courts. The interplay of the international criminal law and immunities is complex, and the jurisprudence and the authorities have been described as a perplexing, contradictory, confused, or incoherent. However, if one keeps in mind the above mentioned distinctions and the underlying purposes of the rules, one will find that a fairly consistent, coherent set of rules is emerging. The fact that the law reflects a balance means that this balance may be course of continue to shift over time. So this lecture discussed the immunities of the individuals in relation to the criminal prosecution for the international crimes in national and international courts. Personal immunities in a civil proceedings and question of the state immunities are not discussed here. Nor this lecture deal with the immunities of the head of the states or high officials in their own countries, which are governed primarily by the national law. So students, functional and personal immunity. With respect to the immunity from the prosecution, a fundamental distinction must be made between functional immunity, also known as the immunity rationi materiae, and personal immunity, also known as the immunity rationi personae. Functional immunity protects conduct carried out on behalf of the state. It is linked to the maxim that a state may not sit in a judgment on the policies and action of another state, since they are both sovereign and equal. If a state could bring criminal proceedings against the individual official who carried out official functions of the another state, the state would doing indirectly what it cannot do directly, namely acting as the arbitrator of the conduct of the another state. Functional immunity attaches to a comparatively large class of the officials, all who carry out state functions significantly. Functional immunity does not provide complete protection of the person, it only covers conduct that was an official act of the state. Personal immunity is not limited to any particular conduct. It provides complete immunity of the person certain office holders while they carry out important representative functions. Personal immunity is granted only to a comparatively small set of people, such as head of state, diplomats accredited to a host country. It is temporary in that it is lost only for as long as the person is serving in that representative role. There is no exception based on the seriousness of the alleged crime or whether the acts were private or official, because the rationale is unconnected to the nature of the charge. The rationale was started in 1740 by the one scholar. If princes had the liberty of proceeding against the ambassador who negotiated with them on any account or under any color whatsoever, the person of the ambassador would never be in a safety, because those who should have a mind to make away with him would never want a pretext. In other words, personal immunity is absolute, but it attaches to a limited set of official roles, and it endures only while the person enjoys the official position which attracts the immunity. Conversely, functional immunity protects only conduct carried out in the course of the individual's duties but does not drop away when a person's role comes to an end, since it's to protect the conduct, not the person. For both type of immunity, the purpose is not to benefit the individual but to protect official acts, functional immunity, or to facilitate international relations, personal immunity. It is the state which is the real beneficiary of the immunity, and it is the state which may waive it, irrespective of the wishes of the person claiming the immunity.